Hey, everybody. So we are waiting for the verdict. The judge said that after he handled his morning calendar call, he would read his decision. So we're on the seal. I don't know if he's going to be exactly. Oh, I'm behind a little. All right, we're still on the seal. We're still on the seal. And I'm interested to see if he goes into some detail about his findings or not. So I don't know what we're going to see here. I mean, it is true what the prosecutor said for the elements of something like battery. There doesn't need to be apparent injuries, right? So just because there are no injuries doesn't mean we can't get to battery. But at the same time, to me, my personal opinion, you can totally disagree. I think Carolyn's story of somehow she thinks she's wrestling on the ground of the main boat with the friends, and she says she's pushed off and she's sitting there having a conversation while looking back up at the boat until they throw her bag down to her, and then she goes through her bag, takes her phone and throws the bag away, and then swims, and then she's clawing and still has her phone in her hand. All of that's just not believable to me. The only way something like that would make sense and she still had her phone was she jumps off willingly with her phone because she knows she wants to go to another boat. Whether or not she wants Cole to follow her is another story. But if he's only jumping on her one time, which is consistent with a lot of the witnesses that the state called, we really only have one witness that isn't Carolyn herself. Well, Carolyn kind of just said she felt like it was a long time. But she didn't say it was like this ongoing, like he kept dunking her repeatedly under the water. It was just that one guy, Alex, the boat owner with the boat hook. So, even what the other witnesses saw, they attributed what they thought was some scariness and intentional conflict to it. But they all pretty much, besides Alex, just saw like one 4 to 15-second interaction. And I don't think it would be reasonable for a judge to say that when there's a viable explanation, somebody sees somebody's shoulders, they jump up because they think they're drowning. I don't think that that's been ruled out. And I don't think it'd be beyond reasonable doubt for the judge to come back and say that battery, domestic strangulation, because there's the second-degree attempted murder, there's the domestic battery by strangulation, and then there's a battery charge. Those top two, I'd be really concerned if the judge feels like both of those are met beyond a reasonable doubt. Battery, sure. Unwanted touching. I think with battery, you have is there an exception? Like, was it somebody was trying to survive, and this is just something that happened when somebody was trying to survive? So, or was it something that happened while somebody was trying to survive, but the preceding minute or two that led up to it, with Cole's decision to jump off the boat, was that decision to jump off the boat unreasonable, and thus it's not reasonable that he needed to be in a position to claw himself up to oxygen? You know, I don't know what we're going to do with that battery charge, but I would really be upset if we have a guilty on the second-degree attempted murder or domestic strangulation. So, and I think it's a testament to the type of thing that if you get into a scenario, or not to put anything personal on anybody, but have you guys ever witnessed like a couple get into a tiff and things go left? Like, have you ever seen a situation that maybe could have ended up like this, even though it really wasn't what this has become? Like, you just never know. Adventure Errands is perfect timing. I literally just finished the divorce court episode. No, you didn't miss it. We're waiting here. And good morning to everybody. Big J Money was here holding it down, making sure we were ready to go for a good stream. Big thanks, J Money. Created by EJF saying, good morning, verdict day. I'm wondering if we're going to have a final outcome in the Ed Holly case, too. Like, is the jury going to say one more time, like, look, we're still deadlocked? So the Ed Holly case, that Orange County, New York case, where the jury asked if they could Google DNA. And then they subbed out an alternate who's like a science teacher and has background in forensics, is what the news reported. They swap her out, they bring her on the panel, and then the jury sends a question in like, Is the new juror allowed to bring in her expertise? Like, it's a mess. It's a mess, that Ed Holly case. Well, they said again they were deadlocked. The first trial for Ed Holly was a hung jury. So, I don't know. I feel like they might yell at the judge to just let them go home today. Also, housekeeping, you guys. Anthony Sims. I don't know if that's a familiar name because I think the only time I may have talked about that case was on Twitter, really just sharing an article that would have included his case. The New York Conviction Integrity Unit, it's supposed to be a program that oversees and reviews claims of wrongful convictions for the sake of, one, getting some heads out of beds and reducing prison facility overcrowding, but two, doing the right thing, right? That's also important. And Conviction Integrity Unit, it sounds great, but there are some, is it really doing the job it's supposed to do? Who's in charge of reviewing these convictions? And oftentimes it's prosecutors, sometimes even prosecutors that were on the trial where the case they're reviewing, they were the trial prosecutor. And they're there to review the integrity and say, well, do I think I did a good job in this case? So a bunch of issues. Anthony Sims is one of those cases. A New York Court of Appeals overturned his conviction yesterday. So some point today, we're going to do a stream. We're going to read like a whole timeline of his appeal efforts. We're going to watch oral arguments and we're going to read the decision. So Anthony Sims is now officially, his conviction is going to be vacated. The state seems to be hinting that they're going to appeal that decision, so it might not end there. But the good news is he's been out on parole since December of 2022. So he's continued to fight for his innocence, but he at least hasn't been in custody since December 2022. So Anthony Sims, we're going to look at that sometime today. And I haven't watched the oral arguments or read the decision, but I just know it's a positive outcome. So let's see. EJF says, yes, I'm just glad we got some coverage on the Ed Holly case. We don't get much court coverage around here. And I keep sharing, you guys might have heard me say yesterday, the Ed Holly coverage is like a reporter who's in the court is doing updates over on Facebook, which I think is a bit more difficult to access because usually when you try to click a Facebook link, it's like, can you sign in? And you can't really see. So it's not really the most accessible information. But if Ben Nandy and the organization he writes for are like, hey, you know, we got a lot of foot traffic. People are interested. We're getting some attention by covering these things. I think it would push news coverage to prioritize courtroom updates, coverage, transparency, reporting. So always got to hit that like button to support what you want to keep going. Trikisha says the judge is hard to read. I think so. And he's been like, yeah, that was an extremely leading question. And he said like these little quips to both parties. And maybe in part because the jury's not there. Maybe he's like, I get to let it all out. So, Miss Cal's, good to see you. Happy Friday Eve. Oh, I won't let anyone know you're here, Erin. I saw your other post, but the Erin gang is all checked in. All checked in. We'll just say that. Christy, good to see you. Christy and Kristen, good to see you. Hey, FFS. Did I tell work that my goldfish is drowning? No. Okay, so for like the last 12 hours, I was preparing myself to tell them I've got to leave at 10:30. It's important. And I was prepared if they like asked why to be like, well, there's like something, it's like a court decision that's coming down and I've just got to cover it. And like trying to explain that to them. And then I'm sitting on the Zoom meeting. It's 10:04, 4 minutes after it's supposed to start. I'm like, where are they? So then I look at my phone and they're like, hey, can we push the meeting to tomorrow? So here we are. No work meeting this morning. So after all of that mental, I was prepared to tell them I had to leave. So we've got FFS in the building. We've got Gloria. Good morning, Gloria. Gloria says she's been in the bushes a few days. It's like that sometimes. Hey, Seamish. We've got Angelica saying hey to everybody. But yeah, guys, I'm excited to talk about that Anthony Sims case. We watched the Daryl Ewing oral arguments yesterday. That was funny. That had to be one of the most entertaining oral arguments we've gotten to watch. And it was the prosecution's petition, so the state's the one that's really got the burden, the heavy asking. Oh, that was a mess. That was a mess. And then a law student, this is not a slight to the law student, it's very cool for the law student. There's two co-defendants. For the one co-defendant, a law student with a provisional license did the arguments. And she did great. She did great. And the justices are like, well, let's ask some law questions to you. Just loving her. And the state prosecutor gets back up there for rebuttal, and instead of like continuing to address the arguments that are relevant to the case, he starts giving additional context to the law question that the law student was talking about. So that was fun. If you want to watch some oral arguments, that was last night. That was Daryl Ewing. His co-defendant is Derek O'Searcy. That's over in Michigan. That was a very good time. We've got Patricia in the building. Good to see you. Good to see you. And man, I want to talk about this Andy Sims case so badly. The background, it was kind of oh, we got movement in the court. It was kind of high profile. It was Bushwick. It was a worker at a Chinese restaurant who was shot and killed because the chicken was raw. And seems like the guy who was convicted is actually his best friend that might have done it. And nobody seemed to care. Even though the guy was like, yeah, I mean, I cleaned the gun off the fingerprints and all of that, but I have nothing to do with this. So we had some other witnesses recant. We had other witnesses come forward and identify the best friend named Graves. And yeah, we're going to see how it all comes together. But it's been like years and years and years that they've been fighting for this. Yep, that was the story. And I don't think that details change. I still think that was the story, that the chicken was raw, and that was someone was mad about it. Maybe there's a little bit more to it. Maybe there's like an ongoing beef with this restaurant. This is the final time you're getting this wrong. But I don't think that context changed. I think it was just attributed to the wrong suspect, wrong culprit. So we're still gonna call it the chicken shooting. Hey, for always, good to see you. Hey, Sirach. Hey, Jody. What's Law and Crime saying? Let's see. Someone's saying they can only do Corey in bits. Can't do all of the Corey Richards trial. We've got someone saying, I think because they did battery with strangulation, it's a felony charge. They're saying me either to somebody. Maybe they're talking about a plea deal. Oh, someone's saying there is a misdemeanor battery statute. I think the regular battery is just a misdemeanor here. Because again, it's those 3 charges. Oh, okay, and then someone says here. So you've got the domestic battery by strangulation, it's 3rd degree felony. Lesser battery is misdemeanor, I guess, is double M. So, and I think that's right from what I was looking at yesterday. That guy Nick says this is why Gordon Ramsay isn't armed on his shows. This is raw. Keith, good to see you. Checking in from Chicago. Hey, Shia. Good to see you. Hey, Destined to Be. Hey, Eve. Eve and or Starfish and Coffee. Whichever you want to go by today. I guess YouTube's choosing for you. Right? My chat's been stuck on the @ names for a long time, right? Is that every YouTube channel now that has the @ names? Law and Crime has it right now. Are there any channels out there that still do display names in the chat? Yeah, Polly Smith feels like I agree with Polly Smith over here in the Law and Crime chat. She says, I can't see a verdict of guilty, but who knows? Like, and that's the scary thing. I never know. They're saying the judge is currently deliberating. He's gonna come out and say he's hung. Oh, also yesterday, you guys, we were talking about when we were looking at the uh, amici brief to SCOTUS, urging them to consider, the use of lyrics in the sentencing phase of trials and to prohibit that. Um, Doug popped in, mentioned like, oh, hey, this guy Dunbar, we wanted to bring him in, but they didn't put on a case in chief, as a lot of you guys know. And then Aaron went and found those. It was the April 2023 pretrial hearings about the admissibility of lyrics. It's 2 days. If we cut out breaks, it's probably like 10 hours total. I was thinking maybe we could rewatch that. But while we rewatch it, we could look at the contemporaneous law and crime chat comments. So we'll be in like a time capsule seeing what they were saying in 2023 while we rewatch. One part of it's going to be the voir dire of this expert witness Dunbar that Doug Weinstein wanted to call. So Judge is going to say he's hung, but he's also made a decision. I love the chat. Free little ham hock. Is that a judge reference? He's gonna read this chat and change his decision. He's gonna be like, screw you, chat. Dang, I could start getting through this Anthony Sims case while we wait. If I start doing something, guys, figure out something that we could start doing. Because as soon as we start doing something else, I'll hear the court commotion, and that's how it goes. That's how it goes. Oh, okay. Lil Ham Hock is from when we watched the law and crime comments from the 2023 YSL stream. Okay. Yeah, I think we should do that. That would be a good time. Oh, man. Yeah, now we all need to know. We all need to know. We'll do another YSL reunion, you guys. We'll go back to 2023. Oh, see, this is concerning. This yeah, okay says, don't think 5 people all perceive the wrong thing. First of all, there's 2 problems with this. 5 people can perceive the wrong thing. The second part is these same 5 people all gave conflicting accounts. So, and they were all giving their statements while sitting at a round table, handing paper and pen back and forth. In fact, the probable cause affidavit doesn't even distinguish. It'll be speaking like a sentence as if, oh, a witness was saying this, but the probable cause affidavit doesn't distinguish who the line by line is even coming from. The probable cause affidavit, for the most part, treats it as one collective omnibus statement. So, which I don't think that's how probable cause affidavits should be written. Mr. Big Play Bray says rappers need to put a disclaimer on the songs on the albums. Like, this isn't real, but it's not real, but it's real. Because they got to keep up the appearance, Hey, Amy, good to see you. Hope you're doing well. I tried to go to Club Classy last week and realized you guys were off for a month. Hope everyone's doing well over there. Oh, man. We had a head just walk across in court, but no movement. Ooh, they're arguing in the chat about this 5 witness comment. This one says 1 witness, yes, 5's not possible. Oof. Yeah, you could pick 12 people out of this chat and get yourself convicted no matter what the facts of the case are. Sir Justice says when one of the five starts by saying it's an attempted murder, then it's easy for the rest to go along. All right. Judge, shout out to Kathy. Kathy says Judge just finished another case. They are taking a break and then he'll come back with the verdict. So maybe she'll tell us the break estimate. Very efficient courtroom. Oh, and Truth Hurts also says not get up on the witness stand and just outright lie. You know better than that. I mean, I don't think a lot of people with misperceptions realize that they're lying. They're saying what they think they saw, what they think they perceived. But then there's also people that would get up and outright lie, or that have over time convinced themselves that the story is this big snowball when it started with a little dot, a little speck. Oh no, that's honestly it was meant to take you to the gutter. My bad. It's unexpected because I don't really go that route all the time. But that time that was a gutter reference. So, Tarted Time Vodcast says it's a dark romance author. My mind went straight to the gutter when Kat said the judge would come out and say he's hung. Nope, that's what it was meant. So, YSL Kel says, here, I couldn't get into this case, but I'm happy to see a verdict coming. Well, I'm glad you say that, because yesterday, and Trakisha joined in with me, I was like, you know what? Dale Warner case has a verdict. I watched the beginning of it, and it was great watching it with Misdemeanor. I love her commentary. But the case itself, I'm just like, all right, this guy's like, never does any welding, but the last time anybody sees his wife Dee, he's like in the back of this huge warehouse going and getting the welder and like looking around all weird, and then nobody ever sees Dee again until they find her welded in a tank and all this other context. I'm like, yeah, I don't know. This one's not really, I don't really feel the need to pay attention to this one. But when the verdict came up yesterday, I'm like, oh, let's watch it. So EJF says my mind lives in the gutter. Yeah, they had beef over raw chicken. Oh, man, I miss New York Chinese food. I miss it. Nothing down here is close. Oh, Kathy says it's Cole's birthday. Oof. Oh, can you? Oh, what a mix of emotions. These people in law and crime really think these five witnesses all saw the same thing. Like, they couldn't even decide if Matt had a floaty or not, or who threw floaties, or who had to throw more than one floaty, or how much they had to drink. $27. That's a that's a number that carries a lot of suspicions. Taboo. Sirach says, I wonder how long the judge reviewed the evidence yesterday and last night. I mean, I feel like I wonder if he's just been like going, like as he goes, like noting, like, oh, well, I would include this in my decision if I ultimately go this way. I also tried to look at the docket yesterday. I didn't see anything submitted on, you know, charges, jury instructions. I just wanted to see if they're like, what if it had been a jury trial, what they would have been requesting and having to argue over. So maybe he got hammered last night just in case. Yeah. No, that sounds like an easy way to be puking in the courtroom. Brian says, can you go straight to Kelsey Fitzsimmons' pre-trial stream after the verdict? So I think I'm going to be covering Anthony Sims, the appeal process for Anthony Sims' case, the New York case. But I would imagine, I think it's probably safe to guess Melanie Little will be live. I feel like anyone who's not making Corey Richins a priority probably be covering, like I bet Nick Starro would probably cover that live. Let's see. Let me see if I do a search. Who's coming up for Kelsey Fitzsimmons? Okay, so Melanie Little's already live. Oh, the hearing's already going. We can watch the hearing. We'll watch the Kelsey Fitzsimmons hearing. I have the court. We'll switch to the court when the judge is in. But just to give us something to do.
Yes, question, any of the questions or not. You folks will have permission to ask reasonable questions.
Let's boost this if it lets me.
Attorney conducted for here. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask. I'm not saying that you can't, but same thing with G. I mean, there's obviously.
Oh, okay. We're live. See? That's why we gotta do. That's why we gotta do something else. Thanks, Shaylee. Works like a charm every time. Oh. Oh, and I forgot to turn closed captions on. My bad.
I know everyone has been here throughout the course of the trial, and everyone has conducted themselves appropriately. I am going to read a verdict, so if you don't feel that you're going to be able to handle that, I would ask for you to step out to the courtroom while we do that.
Uh-oh.
So, thank you all for your time and your patience. I have carefully considered all the testimony, the exhibits that have been entered into evidence, the arguments of counsel, the applicable law, and these are my findings of fact and my conclusions of law. First, it's important to understand what my role is. Ordinarily, this would be a jury trial. In the jury trial, the court's role is limited solely to presiding over the trial and to instruct the members of the jury on the issues of the law. In this particular trial, probably because of all of the extra stuff, which is a technical legal term, that came along with this case, my role is to be both the arbiter of the law and the interpreter of the facts. Many of the issues that were brought up in the trial are only partially relevant to some of the issues of the case. So as such, my job is to limit my view of that evidence, only the evidence which is admissible, and then only for the purpose for what is admissible. So in this role, what are the rules and what rules govern my analysis? Fortunately, the Supreme Court gives us some rules, and they would be the rules that I would provide to jurors if they were here in court. In this case, the defendant has entered a plea of not guilty. So I must presume or believe innocent. This presumption stays with him as to each material allegation in the information through each stage of the trial, unless and until it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. What is reasonable doubt? Reasonable doubt must, whenever the words reasonable doubt are used, I must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such doubt must not influence me to return verdict not guilty if I have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction that is one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond every reasonable doubt, and I must find the defendant not guilty because the doubt is reasonable. It is the evidence introduced into this trial, and it alone, that I am to look for that proof. A reasonable doubt as to the guilt of a defendant may arise from the evidence, the conflict in the evidence, or the lack of evidence. What rules do I have, or what rules do jurors have for deliberations? The Supreme Court gives us 7. In this case, there are 3, which I find to be primarily instructive to guide my analysis. The case must be decided only upon the evidence that I've heard from the testimony of the witnesses and seen in the form of the exhibits and evidence and the jury instructions. The case must not be decided for or against anyone because I feel sorry for anyone or am angry at anyone. My verdict should not be influenced by feelings of prejudice, bias, or sympathy. My verdict must be based on the evidence and on the law contained in the jury instructions. So for me, this case is not a case about Mr. Goldberg and Ms. Schwitzky's relationship. I'm not here to pass judgment over whether or not it was a good idea or a bad idea for them to be together. This case is not a case about whether or not the defendant was affluent, what his family history is from. As the state correctly pointed out in the closing argument, anyone can do anything. Good people can make that decision. And if it's been proven, they need to be held accountable. Ms. Schwitzky's job is not a consideration for me in my deliberation. It's simply not relevant. It is relevant to the issue of bias and credibility. So let's talk about that. Let's talk about what I look at when I'm deciding and weighing the evidence. Which is what I have to ultimately do with the witnesses that were called to testify. It's up to me to decide what evidence is reliable. To do that, I should use my common sense and decide what is the best evidence, what evidence should not be relied upon in considering my verdict. I may find some evidence reliable, or less reliable, or not reliable than other evidence. To consider that, I have to consider how the witnesses acted when they testified, as well as what they said. The things I need to consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? In this case, this comes in the form of different views from different individuals located in different places, under different levels of intoxication. Did the witness seem to have an accurate memory? Were they impeached with their prior statements? Did they indicate that they did not have a recollection of certain things when they were asked questions by one side versus by the other side? Was the witness honest and straightforward when answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? That is ultimately where my analysis primarily focuses. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that's inconsistent with the testimony that they gave in court? So these are the rules, and this is the framework that I have to use when I'm analyzing what my verdict should be. I then turn to the information. The information is the charging document. It's not proof of anything, but it is the formal charges that the state has filed against Mr. Goldberg. It's a 3-count information. Count 1 accuses Mr. Goldberg of committing a crime of attempted second-degree murder. Count 2 accuses Mr. Goldberg of the crime of domestic battery by strangulation. Count 3 accuses him of the crime of battery. With respect to attempted second-degree murder, to prove the crime of attempted second-degree murder, the state must prove the following elements beyond reasonable doubt. First, Cole Goldberg intentionally committed an act which would have resulted in the death of Carolyn Schwitzky, except that someone either prevented him from killing her or he failed to do so. And 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind without regard for human life if it is an act or series of acts that, 1, a person of ordinary judgment knows reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. To prove the crime of domestic battery by strangulation, the state must prove the following 3 elements beyond a reasonable doubt. First, the defendant knowingly and intentionally impeded the normal breathing of Ms. Schwitzky against her will by applying pressure on the throat or neck, or by blocking the nose or mouth of Ms. Schwitzky. 2, in so doing, the defendant created a risk of great bodily harm to Ms. Schwitzky. And 3, at the time, the defendant was in a dating relationship with Ms. Schwitzky. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. Count 3 is the crime of battery. To prove the crime of battery, The state must prove the following element beyond a reasonable doubt. 1. The defendant intentionally touched or struck Ms. Schwitzky against her will. So I then turn to the facts of the case as I see them. The state is correct that when a fact finder, either a jury or in this case myself, is confronted with conflicting views of the evidence, I must attempt to resolve those conflicts if I can before simply deciding that there is reasonable doubt. In any situation with multiple witnesses from multiple angles, there will be conflicts. The question for the court, the question for the fact finder is, are those conflicts such conflicts that it creates in the mind the reasonable doubt? The reasonable doubt can rise as to any of the elements of the crime. So I'll turn to my analysis of each count.
Oh,
With respect
here we
to simple
go.
battery, there was no bill of particulars that was requested by the defense or filed by the state. So I will look at three potential
The initial
theories of
vote.
prosecution for simple battery. First, the throwing of the seltzer bottle at Ms. Schwitzky. Ms. Schwitzky testified that Mr. Goldberg threw the seltzer bottle at her, it hit her in the face, it knocked her down. She felt violated, but she did not believe that he did it intentionally. The defendant denied that it happened, denied that it hit her. There were no independent witnesses to this event. There were no injuries that were observed to Ms. Schwitzky's face. Based on my review of the evidence and the photographs and evidence, I did not observe any injuries consistent with being struck in the face by a seltzer bottle. So I have a reasonable doubt based on that conflict of evidence.
What about the
That is
second?
theory of prosecution. The second theory of prosecution for simple battery was the allegation that Mr. Goldberg grabbed her and wrestled her to the ground on the boat. Ms. Schwitzky, Mr. Goldberg denied that he grabbed her against her will. He indicated he was trying to comfort her or prevent her from jumping off of the boat. Ms. Schwitzky testified that he grabbed her, wrestled her to the ground, that he bit her, and scratched her with his nails. There were no injuries consistent with bite marks that I was able to observe from any of the photographs that were introduced into evidence. There were no injuries visible on Ms. Schwitzky consistent with scratch marks from nails. Ms. Schwitzky alleged at one point either he digitally penetrated her or he roughly grabbed her in her private area. None of the witnesses testified that they saw this. None of the witnesses reacted to this. If there was documentation of these injuries, it was not provided to the court.
What about this drowning moment?
None of the independent witnesses on the boat indicated that they observed him holding her roughly in that manner. None of them indicated that they heard her screaming at the top of her lungs. So I do find that there's a conflict in the evidence such that there's a reasonable doubt as to this theory of prosecution. The final potential theory of prosecution was that after that incident took place, the wrestling on the ground, that
What do you
Mr. Goldberg
think?
threw her off of the boat. Ms. Schwitzky clearly testified several times on both direct examination and cross-examination that Mr. Goldberg threw her off the boat. Mr. Goldberg denied it. Mr. Whiting, who was on the other boat, not the trash that boat, he explicitly denied that she was thrown off of the boat, and he testified on
This
both
is
direct and
good.
cross-examination that she jumped off the boat. Mr. Boland also testified that he observed her jump off the boat. On this record, I cannot find that this theory of prosecution took place. Therefore, the verdict of the court as to count 3, simple battery, must be not guilty.
Woo! Let's go,
With
Chip.
respect to attempted second-degree murder,
That's it. You can't get. Come
attempted
on.
second-degree murder involves an act which would have resulted in death. Imminently dangerous, with a depraved mind without regard for human life. The classical example of second-degree murder.
Why'd he leave the
is
strangulation for the last?
With a firearm, firing gunshots into
Uh-oh.
the crowd without any specific intent to harm anyone. But that act is so imminently dangerous to human life and shows a depraved indifference that they would be guilty of attempted second-degree murder, even without an intent to kill. I have only been able to find in my research a single case regarding attempted drowning. That case is Mook versus State. 293 Southern 3rd 32. It's a 4th District Court of Appeals case from 2020, binding on this court. The facts of Mook are only briefly stated because it is a collateral attack to a conviction. But in that case, the 4th District Court of Appeals upheld the conviction for attempted second-degree murder when the defendant threw his girlfriend off of a boat, then followed her into the water and pushed her underwater at least twice.
At least twice.
So what facts do I have in this case?
At least twice. This is
There are
good.
several
I think this is
different
good.
Facts that I find to be germane to the court's analysis as to imminently dangerous to another, demonstrating a depraved mind without regard for human life. First is the time that Ms. Schwitzky was submerged under the water. Mr. Paris, who was the individual that provided her aid when she was under the water, testified that she was under the water for approximately 4 seconds. Rachel Tarachek
One time.
testified that she'd been under the water for approximately 10 to 15 seconds.
One time.
I believe it's Sherilyn Tarachek, that the other Ms. Tarachek, Mr. Paris's former wife, indicated that Ms. Schwitzky was underwater, quote, longer than normal, but she could not give a specific time. Alex Tarachek, the owner of the boat, testified she was under the water 5, 6, maybe 10 seconds. Mr. Boland was not able to provide time that she was submerged under the water. Mr. Whiting was not able to provide time that she was submerged under the water. Ms. Schwitzky testified that she was under the water 30, 40, or 50 seconds. The second thing for me to consider is whether or not there was a struggle, whether or not Mr. Goldberg attempted again to re-submerge her once she came up for air. Mr. Paris indicated that there was no struggle, that he simply helped her with his hand, lifted her up out of the water, she got on the boat. No one said that Mr. Goldberg went after her a second time, other than Mr. Alex Tarachek. Mr. Alex Tarachek clearly testified that the defendant again attempted to submerge her under the water. Mr. Boland specifically said that Mr. Goldberg did not go back after her.
This is good.
Ms. Schwitzky testified that once she was saved by Mr. Paris, she had to be thrown back in the boat because she was not able to get back in the boat. Next is the manner in which she was submerged. Mr. Paris, Ms. Rachel Tarachek, Mr. Alex Tarachek, Mr. Whiting, and Mr. Bullard all testified to different manners in which they observed Ms. Schwitzky being submerged under the water. Mr. Paris demonstrated 2 hands on her shoulders, not clasped around her throat, but in the throat area. Ms. Rachel Tarachek's demonstration was similar, with the hands closer together. Mr. Alex Tarachek's demonstration was closer together. Mr. Whiting, I believe, testified that there was one hand placed on her head. Mr. Bullard also testified that he was not able to observe it. Ms. Schwitzky testified that Mr. Goldberg grabbed her and she believed that she was being attacked like by a shark, that she was thrown around like a rag doll, back and forth. There were no injuries that were consistent with such a violent manner in which that she would be submerged. So based on this conflict in the testimony, the court has no choice but to find a reasonable doubt as to whether or not a person of ordinary judgment would know that their acts are reasonably certain to kill or do serious bodily injury to another, or that the act is done from ill will, hatred, spite, or evil intent, or is of such nature that the act itself indicates an indifference to human life. Additionally, I would note that it wasn't until Mr. Goldberg's cross-examination that it was discovered that Mr. Goldberg had reported on the day of the incident
He was
that
drowning.
he was having difficulty swimming to Fish and Wildlife approximately 20 minutes after they began their investigation. So because I do not find that there is proof of each element beyond reasonable doubt, the verdict has to count one constantly not guilty. The final element for me to prepare, the final charge for me to consider is domestic battery by strangulation. There are 2 theories by which the state can pursue conviction for domestic battery by strangulation. First, that the defendant knowingly and intentionally impeded the normal breathing of the victim against her will by applying pressure on the throat or neck of Ms. Schwitzky. I do not find that anyone testified that that was what occurred in this place, that he physically choked her and there were no injuries consistent with
This is not guilty.
with her being choked. But the second and more likely theory of prosecution is that Mr. Goldberg intentionally and knowingly impeded her breathing by blocking her nose and mouth with water, and in so doing created a risk of great bodily harm.
I don't think he sees intent.
I previously discussed the conflict that I have with respect to the manner in which she was submerged under the water, which gives the court concern with respect to the creation of a risk of great bodily harm and the intentional knowing and intentional impeding of her breathing. I don't find, based on the record, that the evidence supports any of these elements beyond a reasonable doubt.
Woo!
Thus,
Not
the verdict
guilty.
must be not guilty. So, accordingly, for these reasons, I do judge Mr. Goldberg to be not guilty. I'd ask the clerk to provide me an order adjudicating him not guilty.
What are we doing? Hold on, what is this guy doing, chat? You gotta watch this, chat. The guy in the camera is hilarious. I'm putting that guy in my post.
Today's birthday. Today's his birthday.
Oh, is that like his dad or something?
Thank you. Thank you all. I told her from day one, everyone's going to love him and hate her. That's what's going to happen.
That's enough, guys. Stop talking.
Thank you, Suarez.
Stop. Can you step away from her a little bit?
All right, we're gonna do.
Appreciate that. Back up. You're having a good day. So, yeah. Okay. Thank you.
Have a nice day.
Look, they're all gonna go on a boat party together to celebrate. All right, guys, as what is customarily what we do, unless I get upset and have to end a stream, like with the Faust verdict, we're gonna do a poll and say, did the judge get it right? Not the jury. Did the judge get it right? You guys know my answer. You guys know my answer. And I think polls are important because in a case like this where the chat is largely, we're all celebrating, you know, I can understand if someone doesn't want to chime in and vocalize like, hey, I actually disagree with the judge. I think the elements were met. I think everyone was credible. I think a poll is a good way. And I don't want anyone to think or assume or feel like they'd get jumped. I don't want that environment here. But a poll is still a way to express a thought without having to say it out loud in the chat. So let's do a poll. Let's do the poll. Did the judge get... So you guys be the judge of the judge. The guy with the camera pointing is killing me. And so we've got some out loud comments. We've got he did. Let's all go to Boca Bash. Gwyneth says, I get to keep watching trials. Yay. Brittany says, enjoy your birthday and your freedom. Heck yeah. Heck yeah. Yeah, I wonder if it was the dad that was yelling. Lots of happy birthdays. Oh, what a birthday gift. What a birthday gift. The opposite result in the other direction. Whew. Einstein, love the name, says happy birthday. All these guys have the same hairstyles. Let's see. Yeah, Emily says, to be honest, a dude's still friends or friendly with an ex for years and then not after a single girlfriend, then back to being friendly, low-key, said all I needed to know. And I think stuff like that is pretty implicit, right? And I didn't get the read that was, we're friends because I still have interest in somebody. It just seems like middle school, high school, and then adulthood, you know, you still have the same friend circle. People date other people. I didn't look at it as some like, oh, he can't let somebody go. And I don't like to have bad blood with friends or like exes or friends, like platonic friendships. I don't like to end anything with like bad blood. I might not have spoken to a person since I decided to part ways from them, but it wouldn't mean that like, I think they're a horrible person just because we broke up, you know? Trikisha says, I think I'll go with a bench trial each time. Yeah, depending on the judge, though. Depending on the judge. Depending on the judge, Trikisha. I'm sure you have a few judges in mind that would make you say, nope, don't want a bench trial. And then let's see. We've got, do you guys want, when this ends, because I need to do something at 1 o'clock, so I think the appeal stream we're going to do, I'll do in the afternoon or evening today for the Andy Sims case, because I don't think I'm going to have time to do it in an hour and a half's time. So if you guys want, I'll send you over. If you guys want to watch Kelsey Simmons or Corey Richins, let's see how the chat reacts to the suggestion of Corey Richins. I think a lot of people will be like, yes, but a lot of people will be like, please no, please no. Christy says it's the first time I've seen a judge trial render an acquittal. Interesting. I don't watch all that many bench trials, but I feel like, we get to read the decisions from judges that make the call in certain cases. And I think maybe 50-50 is the way that I would chop it up. Also, Moses. Holy moly, thank you, Moses, for the 5 gifted subs. He's like, for each piece of reasonable doubt. Each piece of reasonable doubt. It's interesting. He started with the battery charge first, then went to the attempted murder. But I guess he did that because he was thinking of the events in chronological order. And it's kind of a bit of a suck state. He could have found battery through any one of those stories that allegedly took place throughout the day. And he said, no, I don't think if maybe on this one aspect, if the court had been given a witness to these injuries or any other type of supporting evidence about these injuries, he's like, but I didn't get that. So it's kind of a nice little, you guys didn't prove your case. You guys could have produced stuff, but you didn't. Sharon Yaxall says, now I hope they take this as a lesson and go party responsibly now. Yeah. What a crazy thing. I feel like every trial it's like, well, lesson learned, don't do this. Here are the lessons like, don't think you're like Aquaman or Mara or both as a couple, as a unit, and jump off a boat while you've been drinking and you've been out in the sun all day and think that you can swim where you're not going to be able to have your feet touch the ground. You don't have any flotation devices. It's just you and your bikini, you and your swim trunks. Like, yeah. So, also, big thank you again to Moses. Seeing lots of love in the chat for Moses. Meow says, love the cat. Well, I love your name. I think we go hand in hand. We've got... Okay, Adventure Aaron says that was Cole's dad. He's a real estate attorney. That checks out. We've got lots of booms here for Moses. Emily says, I definitely think a jury could have said it met all the elements, but on the law, when you're supposed to give every inference to the defendant, there was no way to not have reasonable doubt. And I think the danger with a jury, and maybe they would have requested a bill of particulars if they're gonna do a jury trial. But on that battery charge, imagine if the jury is like, all right, well, it seems like they were tussling on the boat. She jumped off on her own. We don't think he was trying to drown her, but give him the battery for the earlier incident. Split the baby. So, wonder how the civil trial will go now. Well, according to her testimony, she said she just wanted it all to be over and that she actually wanted to sue the Boca Bash promoters, the organizers. So, and again, I only see that the party named as a defendant is Cole himself as an individual. We've got Brian with the happy birthday to Cole. Court TV's mad. Let's see. I think the state's witness were better for the defense in this one. I always love that. I think what was better for the defense is you have the one guy that's giving really great testimony for the state. He was trying to murder her. And he was telling people contemporaneously he's trying to murder her. He seemed aggressive and off his rocker. And I'm not trying to make any further characterizations of that individual, but there are people that I've known in my life, especially thinking of when clubs let out, when I used to do events. And when clubs would let out in an area where all the venues were close together, you would literally call it the let out. People would be standing around for like 30 minutes to an hour getting food, hanging out, scoping for someone to go home with. And every once in a while, if there was like a fight or an argument and somebody was upset, sometimes you'd see people go and try to comfort the person that was upset. And that seems like the natural human thing to do. But every once in a while, it'd be like someone might look vulnerable and upset. And someone kind of is like going over to them in like the shadows, trying to comfort them, like be a hero. And we would make sure someone would go over and like, hey, is everything okay here? Because you never know if that person that's trying to put the cape on and be the hero is expecting something in return or is just looking for a way to have his foot in the door. So sometimes that overbearing protectiveness, it comes with a sense of like expected reciprocity. And I don't always think it's good-natured. I don't always think it's accurate. I think the perceptions get haywire when you go 10 toes down. Whatever I just witnessed is exactly what I just witnessed, and it's as bad as what I just think I witnessed. But I don't know. I have some concerns about people that jump the gun with what they think happened and then immediately start parading to everybody else what they think happened. We've got, let's see, Moses says, do you think Caroline will have her probation revoked? I don't think so, because I think they would have done that, and I don't think that deciding to revoke her probation, I mean, I guess she testified that she had the drinks, but at the same time, I guess it depends on her PO. It seems like her PO had questions for her when they first heard that this story happened. They saw it on the news and they're like, oh, that's Caroline. What are you doing, Caroline? Oh, we'll just extend your time. But to raise an issue now with, I don't know. Interesting. Good to see you, ... Says, hard to say, Judge Bev recently acquitted in a murder bench trial. Interesting. I want to look at that one. I think it's cool when, like, something happens in the opposite direction of what, we might, at a gut feeling, expect. Let's see, we've got, Monica says, I missed this trial. It was only 3 days, and might be interesting to rewatch. Might be interesting. 2 times it. Skip the breaks. Let's see. YP says, today's actually supposed to be good for Richins. Defense dropped a bomb, sidebar was called, and judge ended the day with no resolution. Uh-oh. I am totally out of the loop on that, so interesting to hear. Because no trial can ever just be smooth and simple. Let's see. Any press conferences? Let's see. I'm sure they'll give statements, like written statements, and I'll share them as a post. No, Law and Crime and Court TV are both closed down. I'm sure articles will be published with a statement from Mark. So we've got, let's see. Yeah, the real lesson is not to date women like Caroline. And to have whatever side of the relationship you're on, like, just find a friend that will tell you it's okay to break up with somebody if it just seems like a bad cycle, right? Because I think people think if I break up with somebody, I'm going to regret it. What if I regret it? Well, if you keep doing this tag along back and forth where the dramatics have to get more intense each time for you to prove that you really want to be with that person, I mean, you're never really going to comfortably convince that person that you want to be with them and that you're earnest, you're coming with good faith, unless you just 24/7 do exactly what they want you to do, and that's no way to live. So, yeah, good free. There's a few of them. There's a few good freeze frames. We got the thumbs up. I think I should clip this. I'm gonna clip this guy saying goodbye to the camera, and maybe that will be how we end streams. Just his. We'll do it like the bye, have a beautiful time at the end. Is that American Dad? I think it's American Dad. We'll have one of those clips. He was not guilty on all counts. Not guilty. Let's see. Yeah, an emoji of this guy. Maybe if I could do like a because this is all kind of wonky, but maybe we can get like a doodled version of it. It'll look good. So there we go, you guys. That is the wrap. Oh, Ed Holly. Yeah, let's look at Ed Holly. They're going to get their lunch. It's not lunchtime yet, Erin. Let's see. Then Nandy. Ed Holly case, you guys. New York, Orange County trial. Like, decade and a half old murder, or like 2 decades old murder. There's a low match profile to somebody, that there's other DNA in the sample, guy's on trial, and the jury is like, can we Google DNA? I don't see an update yet from Ben Nandy on that, but when we do our stream later on Andy Sims' conviction being overturned and look at that appeal, we'll look for an update, because that'll be closer to the end of, like, the business day. So there you go, you guys. I have us set to actually go over to Broken Baker. He's live. He's talking about Kelsey Fitzsimmons. So go say hey to Broken Baker. Go rate him. Throw some cupcakes at him. Muffins, whatever your favorite baked good is. And we'll be back probably sometime, I don't know, between 3 and 5 p.m. Eastern to do the Andy Sims case. That is the Bushwick raw chicken killing, where apparently Andy Sims was convicted and spent 25 years incarcerated for something that there were signs somebody else did it all along. Nobody really wanted to hear him and give him his day in court to have an evidentiary hearing. And there's a big mess. I've got a few things that we're going to look at. So, a little bit, Sheriff Chuck. There was a little bit when discussing the 3 possible times that the battery may have been, like the possible theories of the prosecution of when the battery could have taken place. He did say something to the effect of, the court wasn't provided X, Y, and Z, if it exists, which to me is kind of like, those would be the obvious things you would look for if you wanted to bring a case like this and let these charges stick. So, yeah, and the court just doesn't have it. So, there we go, you guys. For the foregoing reasons, enough is enough, and happy birthday, Cole. Thank you, Adventure Aaron. Bye, you guys. Take care.